If you are a green card holder and you have been scrolling through social media lately, seeing alarming posts about deportations, new restrictions, or claims that everything is about to change, I want you to take a deep breath right now. I understand how overwhelming it feels when you see these headlines. I know the anxiety that builds in your chest when someone shares a video claiming your status is at risk. You have worked so hard to build your life here, to provide for your family, to follow every rule, and now you are being told that everything might be taken away. I see you, I hear you, and I want you to know that this channel exists to give you the truth. Not exaggeration, not fear, not clickbait. Just calm, honest, reliable information so you can make informed decisions and protect what matters most to you. Please subscribe to Immigration Path USA for the latest updates about immigration news and changes, so you can stay informed with accurate and reliable information. Today, we are going to discuss 5 significant immigration changes that are being discussed, proposed, or implemented as we move into 2026. I want to be completely transparent with you from the beginning. Some of what I will share with you today involves actual policy changes that have been announced or are in the process of being implemented. Other items involve proposed legislation or policy discussions that have not yet become law. I will clearly tell you which category each topic falls into because you deserve to know the difference between what is real and what is still just a possibility. Before we begin, I also want to remind you that everything I share in this video is general information designed to help you understand the current immigration landscape. This is not personal legal advice, and if you have specific questions about your individual situation, please consult with a licensed immigration attorney who can review your case and provide guidance tailored to your circumstances. Let us start with the first major topic that green card holders need to understand, which involves changes to the public charge rule and how it may affect your status and future applications. The public charge rule has been a source of confusion and fear for many years, and there continues to be ongoing discussion about how it should be applied. As of now, the current public charge rule focuses primarily on whether an applicant is likely to become dependent on certain government benefits in the future. This rule applies mainly to people applying for green cards or certain visa categories, not to people who already have their green cards. Here is what you need to understand clearly. If you are already a lawful permanent resident, meaning you already have your green card, the public charge rule does not affect your current status in the same way it affects people who are still applying. There have been rumors circulating on social media suggesting that green card holders who have ever used any government benefit will be deported or have their status revoked. This is not accurate. Using benefits that you are legally entitled to use does not automatically make you deportable. However, if you are planning to apply for naturalization or citizenship in the future, it is important to understand how your financial history and use of benefits might be considered in that process. The key point I want you to take away is that no major change to the public charge rule affecting current green card holders has been enacted into law as of this recording. There are ongoing discussions and proposals at various levels of government, but discussions and proposals are not the same as enforceable law. Immigration law in the United States does not change overnight. Any significant change must go through a formal process, whether that is through Congress passing legislation, regulatory agencies going through notice and comment periods, or court decisions. Until a change is officially implemented and published, it is not enforceable. The second topic I want to discuss involves the naturalization process and potential changes that could affect your path to citizenship. As a green card holder, you have the right to apply for naturalization after meeting certain requirements, typically 5 years of continuous residence in the United States, or 3 years if you are married to a United States citizen. There have been discussions about potentially changing the requirements for naturalization, including proposals to extend the waiting period or add additional requirements. I want to be very clear about the current situation. As of now, the basic requirements for naturalization have not changed. You still need to meet the continuous residence requirement, the physical presence requirement, demonstrate good moral character, pass the English and civics tests, and take the oath of allegiance. There are proposals and political discussions about changing some of these requirements, but proposals are not law. Until any change is actually enacted through the proper legislative or regulatory process, the current requirements remain in effect. What I encourage you to do if you are eligible for naturalization is to seriously consider beginning that process. Citizenship provides the strongest protection available under United States immigration law. Citizens cannot be deported except in very rare cases involving fraud during the naturalization process. Citizens have the right to vote, the right to petition for family members with shorter waiting times, and the right to travel freely without concerns about reentry. If you have been putting off your naturalization application, now might be a good time to speak with an immigration attorney about whether you are ready to apply. The third area I want to address involves green card renewal and the administrative processes around maintaining your lawful permanent resident status. Your green card itself is valid for 10 years if you have unconditional permanent residence, or 2 years if you have conditional permanent residence. When your card expires, you need to renew it by filing Form I-90 with United States Citizenship and Immigration Services. There have been discussions about changes to the green card renewal process, including potential fee increases and processing time changes. Fee changes do happen periodically, and United States Citizenship and Immigration Services has the authority to adjust fees based on their operational costs. If you are planning to renew your green card in the coming year, I recommend checking the current filing fees on the official United States Citizenship and Immigration Services website, because these amounts can change. One important point that causes confusion is the difference between your green card expiring and your status expiring. Your lawful permanent resident status does not expire when your card expires. The card is simply the document that proves your status. If your card expires but you have filed for renewal, you can continue to live and work in the United States while your renewal is pending. However, having an expired card can cause practical difficulties with employment verification, travel, and other situations where you need to prove your status. This is why it is important to file for renewal well before your card expires. The fourth topic involves travel and re-entry considerations for green card holders, which has been a source of significant anxiety for many people. As a lawful permanent resident, you have the right to travel outside the United States and return. However, there are important rules you need to understand about maintaining your status while traveling. If you are outside the United States for more than 6 months but less than 1 year, you may face additional scrutiny when you return, and an immigration officer could question whether you have abandoned your residence. If you are outside the United States for more than 1 year without a re-entry permit, you may be considered to have abandoned your permanent resident status. These rules have been in place for a long time and have not changed. However, there have been increased discussions about enforcement and scrutiny at ports of entry. What I want you to understand is that the underlying legal rules about travel and maintaining residence have not fundamentally changed. What may be changing is the level of scrutiny or enforcement at individual ports of entry. If you plan to travel outside the United States for an extended period, especially for more than 6 months, I strongly encourage you to consult with an immigration attorney before you travel. They can advise you about whether you should obtain a re-entry permit and how to document your intent to maintain your residence in the United States. There have been alarming posts on social media claiming that green card holders are being denied entry or having their status revoked at the border. While there have been some individual cases that have made news, these situations often involve specific circumstances that are not being fully explained in social media posts. Each case is unique, and what happens to one person does not necessarily mean the same thing will happen to you. However, if you have concerns about your travel history or your ties to the United States, speaking with an attorney before traveling is always a wise decision. The fifth and final topic I want to address involves enforcement priorities and how they might affect green card holders. There has been significant discussion about increased immigration enforcement and changes to how enforcement resources are allocated. I want to address this topic with complete honesty while also providing important context. Lawful permanent residents have significant legal protections under United States law. You cannot be deported simply because someone wants to deport you. Deportation requires a formal legal process, typically involving immigration court, where you have the right to be represented by an attorney and the right to present your case. Grounds for deportation of lawful permanent residents are specific and defined by law. They include things like being convicted of certain crimes, fraud in obtaining your immigration status, or abandoning your residence. If you are a green card holder who has followed the law, maintained your residence, and avoided criminal activity, you are in a strong legal position. The rumors suggesting that all green card holders are at risk of mass deportation are not accurate. This kind of fear-based messaging spreads on social media because it generates engagement, but it does not reflect the legal reality. That said, if you have any concerns about your specific situation, especially if you have any criminal history, even if it seems minor, please consult with an immigration attorney. Some offenses that seem minor under state law can have serious immigration consequences, and it is important to understand your situation clearly. I want to take a moment to talk about how you can protect yourself from misinformation and stay informed with accurate information. The most reliable sources for immigration information are official government websites, particularly the United States Citizenship and Immigration Services website at USCIS.gov and the Department of State website at state.gov. When you hear claims about immigration changes, ask yourself where this information is coming from. Is it from an official government announcement? Is it from a licensed immigration attorney citing specific laws or regulations? Or is it from an anonymous social media account trying to generate views through fear? This channel is committed to providing you with accurate, balanced information. I will never exaggerate or use fear tactics to get your attention. I will always tell you clearly when something is a rumor, when something is proposed, and when something is actually law. You can trust that the information I share has been carefully researched and presented with your best interests in mind. If you are feeling overwhelmed by everything happening in immigration right now, I want to leave you with some practical steps you can take. First, make sure all your documents are current and organized. This includes your green card, passport, and any other immigration documents you have. Second, if you are eligible for naturalization, consider consulting with an attorney about beginning that process. Third, keep records of your residence in the United States, including tax returns, employment records, and other documents that show your ties to this country. Fourth, if you have any concerns about your specific situation, do not rely on social media or friends for advice. Consult with a licensed immigration attorney who can review your case properly. Remember that you are not alone in this journey. Millions of green card holders share your concerns, and there are resources and professionals available to help you navigate whatever changes may come. Thank you so much for watching this video and for trusting Immigration Path USA to provide you with reliable information. If you found this video helpful, please take a moment to subscribe to this channel and turn on notifications so you never miss important updates about immigration news and policy changes. Please also give this video a like, as it helps more people in our community find accurate information. If you have friends or family members who are worried about immigration changes, please share this video with them so they can also benefit from clear, honest information. And finally, I would love to hear from you in the comments. Let me know what topics you would like me to cover in future videos, and share your questions so I can address them in upcoming content. Thank you for being here, and I will see you in the next video.